I think we can start. Everybody can hear me?
Yes.
Yes. All right, just testing the high-tech equipment. All right. Good morning, everyone. Dear ladies and gentlemen, welcome to the event organized by Russian Arbitration Centre with collaboration as Horizons&Co Law Firm and Monckton Chambers. My name is Antonina Slukina. I'm a legal counsel from National Oilwell Varco, and today I will be your guide to this panel discussion. So as you can see, the topic of discussion is breaking down the prejudice, resolving conflicts in the Middle East. I'm very happy to see you all. And without further ado, I would like to introduce our speakers. The first study, we're supposed to have Yulia today, if you are aware, but due to some health issues, we have Katarina Piskunovich. She is a permanent representative of Russian Arbitration Centre in the MENA region. Next to Katarina is Robert.
Hello, it's true.
Oh, sorry.
Unless we can change it.
Sorry. Next to Katarina is Drew Holiner. He is a barrister and arbitrator at Monckton Chambers in London, England. He is admitted to practice in the UK, US, Russia, and DFC courts. And he sits on the panels of approximately a dozen of arbitration around the world. He's also the co-chair of the International Arbitration Institutions and Organizations Committee of California Arbitration. Okay, next to Drew, we have Robert. Okay, Robert Sliwinski. Robert practices as independent counsel, chartered arbitrator, mediator, and dispute board member, practicing throughout the GCC region, Europe, and Far East. He's also the current chair of South UAE branch. All right, then we have Areen Jayousi. He's a partner at Horizons&Co Law Firm. Areen has a deep experience in advising under various international rules, including DIAC, ICC, LCA, and others. Okay, and he is a registered practitioner before the DFC court. Okay, and the next one is Christopher Vajda. He is arbitrator at Monckton Chambers. He is a formal judge in the UK. He also sits as an expert witness in the numerous arbitration cases. I think I didn't forget everyone. Okay, so we start to discuss today event from the briefly highlight the main aspects of arbitration in the MENA region. Katarina, my understanding that you're quite new to the region. Maybe you want to know more about arbitration.
Sure. First of all, I'm just so many colleagues are back from some holidays, so welcome to our discussion today. And yes, you're absolutely right. So it's been only a year since the Arbitration Centre opened an office here in the National Oilwell Centre. And in terms of arbitral institution, this means we opened almost yesterday. So we're quite new. And same as parties do, before taking this decision, we had to look into the arbitration framework in the MENA region. And what we've seen, and I would like our speakers to confirm or contradict, is the very particular system that is driven by rapid economic growth and a mixture of legal cultures and traditions. So to have first brief understanding of the system we're dealing with, I would like to ask Areen to comment on the UAE's legal framework and approach to arbitration.
Sure. Thank you very much. And welcome, everybody. It's very nice to have you in our offices. And it's always good to start bright and early and see such high numbers in the office. So arbitration and the legal framework is an interesting subject. Of course, I can see faces that I do see on the circuit of these events. So I am speaking to people that know the issues involved. But there are sometimes nuances that people either forget or don't concentrate on from a local law perspective, which I think will be interesting and which I will talk about now very briefly before I hand over to some colleagues. Firstly, I've had the pleasure of practicing and working here for the last 17 years in the UAE, particularly in Dubai, where we are now. And it may come as a surprise or a shock that in 2008, when I arrived, arbitration wasn't really a thing in Dubai. Arbitration was not the hot topic it is today. It isn't the cool, snazzy money earner that we all know it to be, and like the academic side of it as well. At the time, which surprised me, by the way, when I arrived, at the time, to be considered a very good lawyer, you had to be a capital markets lawyer or a company and commercial specialist. That very quickly changed, of course, during the crash and the crisis. As soon as the crisis happened, all of a sudden law firms started to ship dispute lawyers and partners that had arbitration experience from London and from New York and from other jurisdictions. And then we saw, of course, the development of existing institutions, arbitral institutions, as well as a very, very obvious conflict in the early days between the onshore courts and arbitral tribunals. Of course, in those days, arbitration was seen as the enemy to onshore litigation courts. They absolutely hated arbitration, arbitrators, and everything associated with both. They saw them as usurpers of their authority and their powers, the judge's power, which I guess I understand, of course. Sovereign courts of a nation and of a land are there for a reason, and of course enjoy a specific position in most societies. So to the Arab legal systems in the Gulf region, in that time, arbitration was new. Of course, in other jurisdictions, it wasn't. In Egypt, for example, a prime example, arbitration has a prominent history and different developments. But it was interesting from a UAE perspective to see the growth, the development, and also the conflict between the local system, the local court system, and the growing and developing arbitration sphere. Of course, fast forward until today, and we can see that arbitration is the preferred dispute resolution mechanism for most international companies. For big local group companies, they also prefer arbitration. Of course, I'm sure we'll discuss the reasons why in more detail and if the trend is continuing in that way. But the Dubai courts particularly, but also UAE courts, generally speaking now, are pro-arbitration. So it's the polar opposite to what I was explaining from at the beginning of my tenure here in the UAE. And there are policy reasons behind that, of course. And I'm a proponent of that specific policy decision. I'm a proponent of arbitration, of course I am. And I think that the development has been quick, dynamic, but also very healthy for dispute resolution practitioners like ourselves. Currently, a final note before I pass on to my co-panelists. Currently, what we see is the courts of the UAE, particularly again, the Dubai courts, being extremely pro-arbitration, particularly on enforcement, which of course is the most important aspect of an arbitration. Because as we all know as practitioners, what's the point of having an award if you can't enforce it and you can't do anything with it? So in the past, it was extraordinarily easy to annul an award, but thank God they brought in 2018 the arbitration law, a standalone arbitration act, a law that greatly assisted in abating nonsense challenges to awards and enforcement of awards. Of course, as Robert, you were saying before, challenges are still present, but the likelihood of succeeding in these challenges is far reduced nowadays, even comparing to 5 or 6 years ago. So there's a healthy development in relation to the strength of awards and arbitral tribunals, and I definitely think it's a positive step in the UAE.
So, Robert, as an arbitrator, do you agree with Areen on the tendency? What do you see?
Areen, yes, indeed, to a large degree. I most certainly agree with you. And arbitration has become the default dispute resolution process in the UAE for commercial disputes, and certainly in my arena of construction and engineering. And which doesn't mean that it can't be improved. Arbitration is not the panacea for all disputes. For example, mediation has been coming into the UAE and needs to be adopted and considered in more detail, and could perhaps be used to resolve disputes in a short and effective and cost-effective manner. But arbitration itself is still very effective. And one of the big problems I find as an arbitrator, and indeed as counsel, is the fact that arbitrations are allowed to drift on too long. And that's despite the fact we have the arbitration law here. We, of course, have the various arbitration rules, the Act being the obvious one here, but ICC, of course, less so LCIA these days. But there are mechanisms within the arbitration rules to allow the tribunal to try and deal with the matters effectively and relatively concisely, and hopefully cost effectively as well. As far as arbitration is concerned in the UAE, yes, absolutely. Most people write arbitration into their contracts. The question is, what have they actually written into their contracts? And that's something that I feel is not dealt with in enough detail at the beginning when the contracts have been put together. What sort of arbitration do you want? What sort of, I suppose, the number of tribunals? Is it a big contract you're working on, or relatively, say, small for the UAE is still quite large, where a sole arbitrator would be sufficient? Which rules are better for you? Looking at interim relief might be something that's worthwhile in trying to decide on the rules you wish to use. Emergency arbitrators, is that something else that may be useful in the future? You're looking in a glass ball, quite frankly. You're guessing. But which rules are going to be best for your contract? Assume you've got that sorted out and you have a nice arbitration running, hopefully without too many hiccups on the way. One of the aspects of arbitration that I personally find, I suppose, frustrating is the number of challenges in arbitration to the tribunal, and then, of course, to the award. Many of the challenges are, quite frankly, without basis or any serious basis. And all it does is extend the arbitration timetable and cost more money. That's something I feel that as users of arbitration and as lawyers, we need to think about in a little bit more detail. Yes, you want to put a marker down for any potential enforcement. Certainly, if you're the responding party and you feel you might lose, you want to put a marker down for any future challenge. But don't spend too much time on it when you know you're not going to succeed, at least before the tribunal. Bear in mind, the tribunal isn't going to willingly walk away from an arbitration. You know, they've been appointed, they wish to continue, they wish to go forward and provide their award, do the best for the parties. So it's got to be quite a strong argument for a tribunal to essentially resign. So that's not going to happen in many cases. And normally you would need a court application, in fact, for that to happen, if there was a serious jurisdiction issue. We'll come on to jurisdiction and admissibility later in the discussion, I think. But there has been a recent case which actually has made life a lot easier here in the UAE, where it's not so much jurisdiction, but certain issues are now considered admissibility. So yes, arbitration is strong, it's working very well, can be improved. Enforcement is a lot better, I have to say, a lot better than it used to be. There are still some onshore judges that don't fully understand, and perhaps there's some education that's required within the judiciary. The offshore courts like the IFC have a better experience in enforcement of arbitration, for example. But the onshore courts are getting much better. And I don't think anyone needs to be afraid of enforcing in the onshore courts anymore.
Yeah, we will discuss some of the problems you raised are definitely popular in many jurisdictions.
Yeah, indeed.
Drew, could you please comment on the Saudi Arabia? Does it have the same approach? Is the legal framework much different?
Yeah, I mentioned I sort of come at this from the perspective of someone. I'm not based in the region. My practice is based in London, but I do quite a bit of international arbitration work, and a lot of it is in line with this event has been with Russian parties. And one of the big issues that has come up, especially over the past couple of years, is parties from that region. We have a problem. The reasons why we don't want to arbitrate in Russia haven't changed. But now we have an issue because of sanctions and so forth. It's difficult in the traditional centers. And there's been a lot of discussion over where can we take our disputes. That's what's sort of driven me to the region and looking at the different examples. And I'll get on specifically the Saudi point in a moment, but I think this has not been a region to where those disputes have traditionally come, at least from that region. And what I have learned that, over these past couple of years is there's a lot of misperceptions. Number one, this is much more arbitration friendly. The GCC countries generally, not just the UAE, are a much more arbitration friendly region than perhaps is the popular perception. It's a lot more diverse with civil and common law backgrounds, sometimes even within the same jurisdiction, and a wide variety of options to choose from as far as resolution of disputes, institutions you can use, and available practitioners here. Come to Saudi, I mean, that's something that's been really, grabbed a lot of people's attention in recent years. And one of the reasons for that is they've seriously modernized their arbitration law. And we can talk about some of the details of that going forward. They just had their first International Arbitration Week in Riyadh earlier this year. Quite impressive. They've made reforms to their enforcement mechanisms to where you can have an award enforced rather quickly. But, and this is true of Saudi and the wider region, I think there's a lot more front loading of practitioners. It's not just, oh, okay, this is a friendly place to go. Let's choose Dubai, or let's choose. There are many very different, how would I say, peculiarities of each jurisdiction that one has to keep in mind. And if you front load that, put a bit of thought into it beforehand, what you need to tailor it to your dispute, you can have some really good options here. But if you don't do that, you might end up with some problems. I mean, one of the examples being in Saudi Arabia, there's a public policy against interest, awards of interest. But I think generally to say, region has a potential, especially for my background, it has a lot of really good prospects to be a good place. That's no doubt why Russian Arbitration Centre, as far as I know, this is the only country in which you have a foreign representation. And the very fact you've been able to set up here shows that an openness and openness to the outside market.
Do you want to
Yes,
comment
I
or
would like,
something?
yes, particularly what Areen said, which is very interesting. I mean, I had a career as a barrister, Queen's Counsel in London. I then became a judge in the European Court in Luxembourg, and I was in fact invited, hearing you speak, I was invited to a conference on international commercial courts in Doha. I was one of the speakers there. And the disputes between the on and offshore courts in Dubai. But what really struck me at that conference, and has struck me since, because I've now, after Brexit, I've left the court, I'm now an arbitrator, is this was the topic in Doha, was effectively setting up these specialist commercial courts. And the reason for that is to try and attract investment. And that replicates very much what happened with the rolled up by the World Bank in the 50s and 60s bilateral investment treaties. And I can see that's the idea, but the what you need to do is need to implement that idea. And the problem, as I see it, with particular court, the court in Qatar, court here, is they have a limited jurisdiction. They do have, by and large, common law judges, but there's a limit to the sorts of cases that you can have. And the first case I did after I ceased being a judge was an ICC arbitration. The seat was in London, but it involved two companies from the Middle East. And what we had there, and it was actually very familiar to me, was effectively English-style litigation, in the sense that both sides were represented. We had witnesses, we had cross-examination, we had expert witnesses. The two arbitrators I sat with were English lawyers. And it was no different from, say, high court proceedings. And then we had a lot of interesting arguments about, you know, the law of Cyprus, the law of India, this, the law of that. But at the end of the day, the process was, I hope you don't mind me saying to those who are not in an English background, it was English-style proceedings. And we then produced an award, which, if you like, was an English-style award. Hopefully it was well-reasoned and so on and so on. And I think international business, they like that sort of thing. And that, I think, is probably why Areen says that's driven arbitration, say, in Dubai, because what you see on the packet is what you get. You get legal certainty, and also, I mean, I sat on the European Court, all sorts of judges from all sorts of backgrounds. Common lawyer, by and large, we like to get stuck into the detail. We like to look at what the witness says. I mean, is in fact the rate of return, is it right, is it not right? Many continental lawyers think that is almost beneath their dignity, because they're there for the opens. And common law also have a reputation of sort of rolling up their sleeves, getting into cases, and not just the lawyer, but also the arbitrators. And I think that is, it was very interesting what you said. I mean, this is very much market driven.
Yeah, thank you, Christopher. Yeah, now we understand that MENA region has its own peculiarities in arbitration. However, I don't think those peculiarities are obstacles to proceed and develop arbitration, as mentioned already by the speakers. So we're gonna discuss now the next topic. We want to unfold the prejudices and see are there any uncertainties to expect from the local jurisdictions due to lack of experience in arbitration. Robert, what do you think about this?
Prejudices. Well, not so much prejudices in my mind. It's more difficulty of common law and civil law, and the difference of lawyers and indeed judges and arbitrators, both civil law and common law. You've got to bear in mind that when you look at the arbitration rules, predominantly they are on a common law basis. It's not set out in a way that a civil law case would proceed in the civil law courts on shore. So you do have submissions in detail. You will have party experts, you will have witnesses who will be examined in the hearing. Whereas, of course, with civil law, normally it's essentially submissions on paper, very little, if any at all, in the way of cross-examination. It's a different way of dealing with things. The tribunal and the courts, of course, are more inquisitorial in the civil law, asking the questions, driving the case forward. Whereas in the common law, of course, it's up to the parties to present their case and for the tribunal to listen. Also, the tribunal will also ask questions, but not in the same way as an inquisitorial court. So those two aspects are perhaps where you may see some form of prejudice coming in, that either one, be the common law practitioner or the civil law practitioner, will prefer their way of undertaking the work. But at the end of the day, the result should actually be the same. If it is or not, it's another question. But it should be, you should end up with the correct result, whichever way you go. When you're arbitrating, and as you're an arbitrator, and you have a civil law practitioner before you who doesn't necessarily fully understand the way that the arbitral process should be undertaken, you need to guide them. You need to set down how the arbitration is going to proceed, the rules that we're following, the evidentiary rules, most importantly, because otherwise you will find that the civil law practitioner perhaps and their client is prejudice might be the right word, but actually is not able to present their case in the way that perhaps they should, which is going to be detrimental to them. If you talk about prejudice, actually in the UAE, I don't think there's much in the way of prejudice at all when we're talking about diversity, which is, you know, a hot subject in most of the world, in arbitration and in litigation. In the UAE, we do have diversity, I'm pleased to say. You do have tribunals who have people from all sorts of backgrounds, from all genders as well. And to my mind, because we do have this diversity, you can then look at the arbitrator you wish to appoint. Are they actually the correct arbitrator for the particular dispute? Hugely important. With regards to any other form of prejudice, but there may be prejudice commercially. There may be, you know, the usual prejudice that you find throughout the world between peoples who don't understand culture. But I think in arbitration, to a large degree, we don't see that. We do have to have an understanding of individual culture, individual background, and take that into account. So, in answer to your question, yes, underlying there's some prejudice, of course, there always will be, but I think by and large in the UAE, that is not too prevalent.
If I may, can I jump in there? I agree with the majority of what you said. If I can just give a Arabic speaker's perspective, which may be controversial.
Please do, yes. That's what we're here for.
Yes, absolutely. So I think that, as you've said, Robert, definitely diversity. I mean, it's been a pleasure to work here, and it continues to be so because of the diverse nature of the jurisdiction. I mean, even in our firm, we have qualified lawyers from over 15 jurisdictions. I mean, it's a pleasure to be in such an enriched environment with different legal cultures. It very much is. But a malaise that was prevalent in arbitration in the UAE specifically, and very much so in Dubai, was the arbitration institutions were seen as a mafia, a racket of certain individuals always being appointed to the same type of cases
Throughout the world.
Throughout the world, I'm sure. But because of the nascent nature of arbitration at that time here, very much dominated with actually quite a small circle of people. I'm happy to say that now that's very different, and it's changed and it's developed in a big way. However, many Arabic-speaking practitioners that are very well versed in arbitration from the jurisdiction and from the region do feel that particularly in Dubai, not so much even in Abu Dhabi or in Qatar or in other places, but it is dominated by English common law lawyers. Right?
It's true.
There are historic reasons for that. There are practical reasons for that. But I think that is a fact, that it's difficult to escape the reality of. That doesn't mean that, of course, Arabic-speaking practitioners don't get appointments. They do, and they have their share of the market, but it's market-driven. So, as you were saying, Christopher, it very much is market-driven. The reality is, your blue-chip companies, your listed entities, they don't want a certain profile, and they want the profile. That's why. That's the reason behind the prevalence, number one. Number two, what you were saying, Robert, about common law and civil law, I think you're right. And I'm privileged to have been qualified in both systems, which was difficult because growing up in England and having been qualified there and studying there, the civil law system was absolutely alien to me in relation to not only the fact that in court proceedings, it's very document heavy. It doesn't matter if there's witnesses or people saw anything or they're signing an affidavit. It only depends if you can prove something by way of a document, which I found quite bizarre at the time. But that's something that even when I'm sitting on tribunals, I often find myself arguing with co-arbitrators about the veracity of evidence, if it's of high value or if it's of low value. Things of that nature are still happening now. Also, the legal culture of the place. Common law jurisdictions have a specific legal culture based on many different factors, but mostly, of course, precedent system and everything else. As we all know, civil law practitioners from all across the region, not just the continental model and French model, have a very different way of looking at case law and using it in their proceedings. So these things, I actually believe, add to the arbitration sphere in this jurisdiction. They don't take away from it. I think the diversity that we were speaking of legal cultures is actually an advantage and not a disadvantage. The last thing I'll say on it is, it also, I mean, it's a very hotly debated academic subject that you said that the arbitration rules are mostly common law. If you said that to a French practitioner or a person from the ICC, they would have a fight with you.
I'm sure they would.
An academic one, of course. But I like that diversity, even in the rules. Now, of course, we believe as practitioners now in this day and age, it's a joy to look at the institutional rules, because generally speaking, they're uniform. They're based on the UNCITRAL models and et cetera, but that wasn't always the case. I mean, Arbitrate AD, we were praying for that, the practitioners in this region, because of the absolute mess that ADCAC was before, right? The rules and the procedural, see, everyone's agreeing.
We don't go there.
We don't go there. So we're in a much more robust position nowadays as practitioners than we were previously, and I think the diversity has a lot to do with that.
Yeah, I'd absolutely agree there. And just adding on to the end of that, the diversity is a plus here, without a doubt. And the mix between common law and civil law is actually a bonus as well. As far as civil law practitioners, local Emirati lawyers or Arabic lawyers, perhaps feeling that they are prejudiced against to some degree, that's fully understandable when you look at the way that the arbitration system works and who generally, looking at the panels, who's there to be appointed. However, if you look at Sharjah, and I'm actually on the Sharjah panel, but of course it's all Arabic.
Yeah.
So of course I will never be appointed. So it's not all in one direction.
Yeah, it goes both ways. Yeah, I agree with you, gentlemen. All right, so the issue of sanctions, very hot topic. You have to add something, sorry.
Yes,
Oh, yeah, I might just add on.
All right.
Slightly to that. Again, from the outside looking in, so to speak, I think some of the biggest issues I have heard about when we're talking to colleagues and stuff about what about Dubai, and then you hear the questions. I think it's also important for local practitioners to know what's going through the minds. I know we did a little survey in advance. I might mention one of those things, but the themes that seem to keep cropping up to me is, one is general unfamiliarity. That's events like this help to deal with that. There's a perception that it's expensive. That might be just sort of the Dubai vibe. I don't know. That's a perception. And for those who have had a maybe more superficial experience with the region, a couple of complaints I've heard is timing, turning cases around, and transparency. I think you touched on it, transparency in the selection of arbitrators, because they're used to either Asian institutions where they have their set panels, published panels, or maybe European institutions where they don't have them, but it's more or less predictable the type of person you can get. So I don't know, as we go on, it might be interesting to see how, what you would respond to how you dispel those sorts of perceptions. Absolutely.
I'd like to comment just on two things on both diversity and prejudice. It's extremely interesting to hear this. First of all, dealing with diversity, and I think points that Aaron made, they resonate very much with me. When I became a judge in the European Court, if you look at diversity, although I was a white man, I was in a sense the odd man out, not because there were more women, but because most of my fellow judges, most of them have not been career lawyers, like practicing lawyers. A lot of them have been professors. Some of them have been in government legal service, civil law. And the court was actually, in that sense, much more diverse than, say, an English court today. And that was really interesting for me and we would have cases where people would come from totally different views. And then one might, reach a consensus on and we had to give one judgment. So you have, And one of my former colleagues came out and was doing a case, and she said to me, "Do you miss advocacy?" And I said, "Well, actually, what you don't know is I do a huge amount of advocacy every day, because when I'm discussing cases, you're discussing with people who come from a very different background." And I totally agree. I think diversity is a real plus. Then just on prejudice, and this was again something I picked up in the European Court, arbitration for the common law, it's well established, is a natural thing, and you don't get the House of Lords or now the UK Supreme Court saying we don't want this arbitration. Indeed, one of the reasons why judges in England are so keen that arbitration in the common law should flourish is that you would then have cases that it would be a source of development and vibrancy of the common law. What I discovered is that in continental Europe, there's a very different approach to that, because the approach is, and this comes to the prejudice point, that judges who are appointed by the state take the view that people, and that would now include me, all of us sitting here, we do not have the authority to judge cases which involve, I can put this, the public interest in that state. And before I left the court, we had quite a few big investor state arbitration cases. And what the court basically said is that's not arbitrable. And it's interesting that I've noticed coming back into private practice, you've had similar judgments in French courts, Greek courts, that even in relation to what one would consider to be a completely commercial context, which is a concession agreement, say building an airport, and there's a dispute. But the courts have said, no, this touches on the public interest, and this is not arbitrable. And that, to me, is really quite. I don't know where the Dubai courts fit into that, but it's not just a question of turf wars. There is a feeling that arbitrators, the sort of people, all of us who are in this room, we do not understand, say, the public interest in Dubai, and the only person who can determine that is a judge. And the question as to how big that area is, I think, going to be one of the interesting issues in most jurisdictions in the coming years.
Mm-hmm. All right. Thank you. Thank you for your view, Christopher. But I have another question. Of course, we're going back to sanctions. Okay, it's a very hot topic, so I'd like to know your opinion.
Well, yes, I knew nothing about sanctions when I was in private practice. When I became a judge, we started having a number of sanctions cases. I was sitting in the European Court in Luxembourg. I did a lot of cases involving sanctions in relation to Iran, the nuclear program, also Syria, and then I sat on the Rosneft case, the first case against Russia. And I found them very interesting for two reasons. First of all, as you may know, under European law, you can't simply sanction somebody for give reasons. And that's developed. And we had a lot of interesting cases in relation to, for instance, particularly Syria, where the amount of information that was available in relation to that country meant that the reasons were limited. And the question was whether that would be enough to sanction an individual, because in a case like Syria, it was very much sanctions against individuals. Now, I thought when I left the court, this is simply a matter of what we would call in England public law. So you go to a court in Luxembourg if it's EU sanctions, London if it's UK sanctions, Washington if it's US sanctions. But in fact, when I came back into private practice, and I was then approached to be an expert witness in a case in Singapore, which involved a commercial dispute between two companies in relation to the construction of an LNG plant in Russia. And one of the parties had said, well, this is now covered by sanctions. We are now going to declare force majeure. And the other party disagreed. And it then came to me that, because I was then approached to be an expert witness in this case, that in fact, these sanctions can actually have massive worldwide effect. What was interesting is not just obviously the question of how you interpret, in this case, it was EU legislation in relation to certain prohibited products, what's covered in the list and what's not. but also the question which both of you mentioned, which is the question, if you then get an award, the enforceability of the award. And the other side had got evidence from a number of states in Europe about how they interpreted sanctuary. This is what we would call soft law. It's not hard law, it's soft law. And that raised the question as to whether or not, if an award was made, it would then be enforceable certainly within the EU courts. And all I really just wanted to do was to show you that the issue of sanctions is not something which is simply confined to within the EU on a public source. It actually has quite a big impact and as I say, the case I was involved was a private construction dispute between two companies, neither of whom had any connection, neither that were Russian companies, but in relation to the construction of plants in Russia.
Interesting. Thank you very much. We're going to another question. Is choosing an arbitral institution. Okay, so we have enough institution in the region. Drew, what is your opinion on this?
Well, so I think, you know, the part of the, you have plenty of institutions in the region. I think that's probably a good thing rather than a bad thing, because you're essentially spoiled for choice. And like I said, I have heard some complaints about some that tend to be slow, but then on the other hand, I think mentioning ADGM, we were just speaking to folks last night about how you can really get quick turnaround from the supervisory court age. It seems that almost, particularly the GCC region, just as important as the choice of institution is your choice of seat, because you have such different aspects you have to deal with here. So I think I mentioned earlier in Saudi Arabia, you have a public policy against interest. So if you're going to have an award with interest, you might not want to choose Saudi as your seat. You have in Bahrain, you have the BCDR, which they have this free arbitration zone, which there's no challenge against the award unless the parties have agreed. I think there's only one place, Kyrgyzstan, I've only known of that has a regime like that. If you choose ADGM or DIFC, then you're going to, as your seat, and it's quite important, choosing the offshore rather than the onshore court, then you're going to have a supervisory jurisdiction of international judges, not local judges. DIFC, has even issued anti-suit injunctions to protect arbitration suit in DIFC. And as far as I know, that's unique to the region. And actually not many places around the world that will do that. But I think that so I think generally I'd say it's a good thing that you have this choice, but what it does is it puts on the drafters of the contract and the practitioners when they are choosing it, it means that you have to, you know, you don't just put the rules in, you have to think in advance how it's going to be tailored, perhaps more so than you might somewhere else. Putting those elements together, what rules are you going to use? What seat are you going to use in the arbitration in this region?
Yeah, it's true. It's true. As I'm a legal counsel, right? So we face a lot of challenges by choosing. If you have a contract and two parties are located in Saudi, and most of the time we will be forced by the customer to use either court or, in the worst case, a Saudi Arbitration Centre. So, however, I'm still very confused. Why should I still have flexibility to choose whatever I want, but I'm somehow forced to choose Saudi Arbitration Centre. So far, this is what I face.
DIFC, exactly.
I can't. It will be Saudi. It will be Saudi. This is my challenging problems almost every time.
But you know, there's a flip side to that too. Is if that's what you're getting, it's probably because you have a Saudi counterparty, right? Because it's a negotiating power. But having your arbitration under the Saudi regime comes with a huge advantage in terms of enforcement with the new enforcement law there. I was going to get this a little bit later, but it might be
it would be quite interesting to hear about enforcement in Saudi.
Yeah,
Mhm.
So under the new enforcement law, if your arbitration is conducted on those rules, there's a very swift procedure. I mean, you can actually file your enforcement application online. It's forwarded to a judge in a matter of days. And if the decision is to enforce, if it's not opposed, then there's no appeal against that. And they will start enforcement literally within days or weeks and can impose sanctions when they are delaying in enforcement. So have a very robust regime. It's one of the big eye openers for myself when we were back there in Riyadh arbitration week I'd done. If your counterparty is Saudi, well, you're probably not going to be exacting interest from them anyway. So then in that case, that might be a very good option, actually. Because SCCA has a very modern set of rules. It's up to the latest standards on like joinder and consolidation.
Yeah.
Have a very good international court represented from very experienced arbitration practitioners throughout the world. So it's new, but the elements are there for a potentially very good system if you're dealing with Saudi parties.
So I'm not supposed to be scared to choose Saudi Arbitration Centre.
If you're not scared to do business with the Saudis, maybe it's good. There are worse options out there.
Of companies now,
Yeah.
but still, as a legal counsel, I'm a little bit concerned. But anyway, thank you for your opinion. All right, Katarina, would you like to comment on the arbitral institutions, especially maybe on Iraq? Yeah.
So as you already mentioned, the seat matters a lot, and further to the seat, you have to choose the arbitral institution. And here, of course, there is quite a variety, as you mentioned. So what makes the institution a choice is how it is convenient for the parties to operate within it, given the seat that you already chose. So with the Russian Arbitration Centre, we can administer cases with any seats of arbitration, of course, given the procedures established there, and with any party. So we have purely Russian disputes, many domestic disputes, of course, but then we have many international cases. And from the statistics that we have now, we have more than 300 cases per year, and 40 of them are international. And this number is growing. So what we're doing, we're trying to make the process as convenient for the parties as possible. We're here to the best global standards and implement them in our rules. And as a result, what we see is the efficiency of the work that results in the average duration of the procedure being only up to 6 months only, which I think in some cases is an expedited procedure, but for us it is quite a standard procedure. And apart from this, of course, what we can offer is an independent forum, and we are free from sanctions. So we are not involved in any sanction measures, and with I would say various parties. And here, what as a non-governmental, non-commercial institution, we have a very special position because this is not quite the case for many of the arbitral institutions that are formed under the government of business. And as you know, yes, we opened an office in the DFC, so that we can help the parties with the arbitration on site. But of course, the other goal was to enhance the trust of the parties, especially the foreign parties, by the international accreditation. So as probably many of you know, opening a company in the DFC is not a simple action. And you have to go through many of the checks and compliances, and they verify that the company is independent and the reports that we submit are true. So we undergone this, and I think this can be a good option for both foreign parties if seek some efficiency, convenience, but also, of course, that if you have a Russian party, this gives an additional advantage because it is quite complicated to enforce a foreign arbitral award in Russia. But having a Russian institution helps to reduce such risk because local courts have a better trust with their position administered by the institution, by the Russian institution. So this, I think.
Thank you. Areen, what do you think? What is your opinion on the institutions, arbitration institutions here in the region?
Yes, I think the most interesting development in that regard was the recent amalgamation of 3 centres into one, which was controversial in Dubai. And lots of you are nodding, so you know what I'm talking about. The DIFC-LCIA just disappeared overnight, which was very annoying for practitioners and cases in the DIFC-LCIA, and also the Maritime Centre and Arbitration Centre in Dubai. But I actually think it's had some advantages in bringing them all under one roof. It was painful at the beginning because of the sudden change, but the uniform nature of DIAC now and how to file and how things are dealt with, I think is moving in the right direction. The co-panelists have mentioned a few times timing issues and the length of time proceedings take. That still is, I think, could be improved, as you were saying, Robert, at the beginning. But of course, I've been here for a while now, and what we have now is far, far better than we had in the past. So I do think that the upward trajectory is a good one, and it's something that we should acknowledge that things are getting better. I think, as my co-panelists have said, there's a lot of choice. Choice is a good thing, of course, and really, in terms of the differing institutions, for us, we have the strength of they're all quite good now, whereas historically we couldn't have said that. The only one that I'm very annoyed with is the one that Drew seems very well versed with Saudi, because they haven't yet appointed me, which is annoying. But other than that, the institutions are strong, which is good to see. I think it's healthy for the region. I think it's good for international business, which of course is good for us all. And I think it's yet another advantage of doing business here and practicing law here, that we have strong institutions. One, if I may, the issue that, and perhaps it's coming, but I think the one thing that isn't well understood in this region is that of public order or public policy, which affects how we do business, particularly local law firms and the advice that we give and the proceedings that we preside over, because it differs from jurisdiction to jurisdiction. It even differs from Dubai to Abu Dhabi, very interestingly. And I think that also is something to factor in when you're thinking of an institution as well. And that's what we advise clients on.
We'll come back to public policy later on, if we still have time. All right, so Robert, do you want to comment anything?
Yeah, I mean, Areen mentioned, of course, the merger into DI and DIAC, the LCIA and indeed EMAG. And that caused, I think internationally, it caused problems, not let alone here, in that there was a perception that is DIAC actually independent? Or is it controlled by the government?
It was my question, actually.
Yeah. Oh, well, I've jumped to your question.
No. It was my question in my mind, because I want to ask Areen, but I just keep silent. But you open up.
And and I think since the merger, it's become clear that DIAC is in fact independent. But there was a real question mark over that internationally, and that may not be fully addressed internationally yet either. And then there was the question of enforcement, where you had the old LCIA rules. And it's now become DIAC rules. Is that enforceable, in fact? Is that the arbitral rules that the parties had actually agreed? You know, can you have a dictate that actually says, no, you're now using different rules? And that's been addressed to some degree. So there was a case in, I can't remember which state it was, in America, where it wasn't enforced because they said that wasn't the party agreement. And yet here, in Dubai, in DIFC, in fact, last year or earlier this year, in fact, it's now been looked at in detail and it's been found to be enforceable.
Okay.
So there is a challenge there. There is a problem in some parts of the world, perhaps. But I think within the GCC region, that particular issue is probably no longer existent.
All right. Thank you.
Yes, well,
we've heard mention by my panelists of the LCIA. Recently, I was having lunch with a partner and law firm in London who was telling me about an institution that I'd never heard of called the Monckton Chambers of Commerce, which set up an arbitration body well before the LCIA. In fact, the LCIA was a sort of offshoot, but the LCIA has become very successful. And he was telling me that for some people, now for smaller value disputes, the LCI is too complex, too heavy, too expensive. And so now the London Chamber are pitching for doing work for what we call SMEs, small and medium-sized enterprises. And, you know, to my mind, that's quite a good thing. And another body, I don't know if they've got a profile yet in this part of the world, is Prime, which is financial regulation. I'm been put on the panel of that, but we haven't had a single case. But because essentially financial institutions the big banks, they want to go either to New York or London because that's where they get certainty. And the whole thing of arbitration is a totally new thing and uncertain, all the rest of it. But Prime are making a big push and they are getting some success in people putting in their contracts arbitration there. And I think coming back to this theme of diversity, which is so important in life today, I think also there is something to be said in diversity in institutions and diversity in approach, which to my mind is a good thing.
Mm-hmm. Yes, correct, you're right. Okay, so we're jumping to the next question, choosing an arbitrator. If there is enough arbitrators in the region, Kate, what do you think?
Well, from our experience, there is enough. And for us, of course, being based here, we explored the arbitrators who are willing to take appointments based here. And there is quite a choice and a good choice between the different legal backgrounds, as I mentioned. Since there, the concentration of lawyers from civil and common law jurisdictions is one of the most diverse that I think I've seen in other countries. So it is great, and we, of course, we keep our databases, and right now there are around 450 arbitrators included in our databases. Of course, it is not only in this region, but including this. And out of them, 50 arbitrators are the top leading arbitrators in the world. So I think there is a good choice, and for the parties, our databases are not obligatory, so they are free to choose someone outside of the list as well. And what we see from our experience, they do choose, but sometimes it is easy for the parties to proceed with the standard procedure. And for us, if it is a sole arbitrator, the board will appoint an arbitrator. Of course, if it is international dispute, then such an arbitrator will not be of the same nationality as one of the parties. And for the tribunal consisting of 3 arbitrators, sometimes we're not taking any parts in the appointments because the parties can appoint each of the arbitrators, and then 2 of them appoint the presiding arbitrator. So it can be a very a process that is completely dependent on the parties, on their speeds. So this can enhance the total I would say satisfaction from the parties from the press. And talking about the arbitrators in the MENA region, right now, with the involvement of the Russian parties, it can be a very important aspect because there was a recent ruling by the Supreme Court in Russia that stated that if the arbitrators are coming from the so-called unfriendly jurisdictions, then there is a presumption that they're biased. So by default, the Russian courts will consider that there was a flaw in the arbitration process of the versus unenforceable. That is why, of course, I think there will be a big rise in the appointments of arbitrators from the region over here.
Interesting. Thank you.
Last question.
Yeah.
Because I understand the Russian court's position and we're taking that viewpoint. Does that talk about where arbitrators are practicing, where they're based, or their original qualification? For example, being UK barrister and English barrister, would that therefore apply to me if you appointed me?
This is actually the question that we're looking forward to seeing yourselves. Because it was just a recent decision. And in that case, it was the nationality of the parties, but all three members of the tribunals were coming from jurisdictions. So it was not even the presiding arbitrator that was neutral. Well, I mean, from the country that is not involved there. So it is yet to be discovered.
Okay. Interesting.
But the case there was nationality.
So that's where enforcement becomes very important, because if you have international arbitrators from unfriendly countries, you need to be enforcing outside of Russia.
Yeah.
Thank you. Well, it depends on the case.
Yeah, essentially.
Yeah, it's true. Okay, Areen, do you want to comment about new generation? Do you remember the question about the new generation? we were still talking about the if there is enough arbitrators in the region. What do you think about this?
Yeah, I mean, many people would say there's too many, which is interesting. I don't agree with that, of course, because I think the more the merrier in terms of what they bring to the table. In terms of and why people generally say there's too many is because everybody wants a piece of the pie in terms of appointments.
Yeah.
But I think each individual arbitrator has their own skill set and specific value add to a case. So I think the more arbitrators, the better. In terms of new generation, that's something that we in this firm take very seriously and want to promote, actually. A new generation of very solid practitioners. I think it would be beneficial for not only the firm, of course, and the individual, but also the legal fraternity here, because the stronger the arbitration community, the stronger the cascading effect on the entire arbitral sphere. So I think other law firms are also investing in this process in terms of training, in terms of introducing individuals from a more diverse background to the arbitral process in their firms, which I think is an advantage, and I think a good thing, something that I'm a proponent of. I think the future in this region is more arbitration, not less arbitration. I think it's a good thing, as I've said a few times, and of course our future is our youth. So I'm a proponent of training our young trainees and young lawyers to be very proficient in rules, but also the legal culture of an arbitration, how to manage an arbitration. I think that's something that not just our law firm is thinking of, but the wider community as well.
Thank you very much. Anybody else who wants to comment?
If I can comment on that, yes, I absolutely agree.
Yeah.
And the training is vitally important for the younger generation of lawyers who want to act as counsel in arbitration, but also who eventually would want to be arbitrators.
Yeah.
Because you need the quality of people. It's not diversity is extremely important, but diversity is no good without the quality as well. You must have the quality and ability to not only represent, but also to act as the arbitrator. And I'll put a small plug in for the Chartered Institute of Arbitrators.
I just want to say it.
Being the UAE chair, obviously I should. But you know, we actually undertake training for arbitrators, those interested in arbitrators, and then eventually those who wish to become arbitrators. And to fully understand international arbitration, I would suggest you join the Institute and actually take the modules, understand arbitration. That will put you in good stead. A small plug there.
It's actually,
That's entirely taking that I was asked last year to give a keynote address to the London branch of the Chartered Institute, and it was one of the points I made about training of arbitrators, because to become a judge in England, it's not sufficient simply to apply. You have to produce pieces of your written work. And most arbitral tribunals, you just get 2 references and you get in, and we've all been in the situation, I'm sure, we've had to redraft somebody else's award. So when you say you have 50 of the leading arbitrators in the world, I wonder on what basis you categorize, because only when you're in arbitration, you see how somebody else works, whether you know that they're any good or not. And I have to say, I think the Chartered Institute does a great job, because I think the ability to draft an award, in my view, and I think looking into the future, I think any institution should effectively introduce something like that before you get onto a panel, because you'd be amazed the number of people who are on panels who can't draft an award. And that's just the sort of thing that the Chartered Institute offers.
If you become a fellow of the Institute, having taken the international arbitration modules, the last part of that, the stage 3 is, module 3, is award writing. And it's quite a tough exam, I have to say.
It is.
You certainly don't pay your money and simply pass it. It is quite tough. So as a fellow of the Chartered Institute Arbitrators, you have the knowledge and at least the academic ability to draft an award. There is one level above fellow, and that's the Chartered Arbitrator, which I'm happy to be one of, which shows that actually you're an experienced arbitrator and you're a trusted, safe pair of hands, if you wish. But fellows are essential, it seems to me, to show that you can actually draft an award and act as an arbitrator. Obviously, there's lots of people who aren't members of the Chartered Institute who aren't fellows, who are very fine arbitrators. I'm not denigrating them, but I think it's a good selling point for up-and-coming arbitrators to show their ability.
Yeah, but some panels, I don't know if the locals, but some panels actually require it as a prerequisite.
That's right. They're also
around the world, not just in London or the Asian institutions.
That's correct.
Thank you. We are jumping to the next question: is the cost of arbitration. Is it really expensive in the MENA region to go to the arbitration? Katarina, I probably will. Yeah, we'll ask you this question.
RC, of course, and panelists get more to the situation with other institutions, but for the RC, we know that our arbitration fees are much lower than usual international arbitration centers. This is mostly due to the fact, for you to understand the context, that we had to compete with the Russian local courts because they're fast and cheap. So we had to keep our rates rather moderate and then keep up to the speed. So that's why we have this time efficiency in the procedures. And for us, the default rule for, I think, most of our parties satisfied with is the ad valorem rate, so that you can understand and estimate your expenses at the very start of the interview. So it's clear, you just put the claim, the amount of the claim in calculator on the website, and you see how it goes. Then, of course, the parties can modify the hourly rates, and they can even modify the hourly rates. For example, if they want to increase them, the arbitrators to receive a bigger fees, it is absolutely allowed. What we also know is that parties sometimes, and especially Russian parties, have difficulties in paying the fees to the foreign institutions. For us, this is not the case because, of course, as being based in Russia, we have Russian bank accounts, but for the foreign parties, as it works both ways, the difficulties, we have a foreign bank account, so that there are no technical obstacles in proceeding with the dispute resolution.
All right. Areen, do you want to comment on the cost? Because ridiculously expensive. It's supposed to be not.
No, I'm joking. So in relation to the cost, I'm going to speak on behalf of clients, really, because the clients come to me complaining all the time about the cost of arbitration. Also, particularly non-Western clients, so local clients or from the region or from the eastern part of the world. They're not used to the concept of arbitration, number one, so they are surprised when they see the cost of an arbitration, including not just, of course not, in fact, it's mostly the cost of the arbitrators as opposed to the arbitration centre. And you have to tell them, of course, that if you are successful, you can recoup the majority of the cost. And that's new to them as well. So it's just, from my perspective, I think the cost, particularly if you are representing a client that has a robustish case, I think the cost is manageable and something that needs to be obviously factored into the approach, generally speaking, but something that isn't exorbitant and too much. To many a client, they will disagree with me and think, okay, I'm going to court if I can. The most common type of inquiry that we get in this firm is, how do I circumvent the arbitration clause? I don't want to go to arbitration. It's too costly.
Yeah.
I want to go to court. It cost me only 40,000 dirhams. So that's very common. That's why I'm saying that was my reaction at the beginning, of course, a bit tongue in cheek. But it is a factor that people take into consideration here more than other jurisdictions, because they are not used to the process as much as other jurisdictions. And it is a negative for many litigants here. There is a preference in large sections of the community here for onshore litigation or even DIT litigation because of cost. And that's something that we have seen. Of course, what makes that worse is sometimes we get some very, if I can speak colloquially, dodgy decisions from the Dubai courts in relation to costs of arbitrations. One, I think, from last year hit the newspapers because of an ICC award that gave the party its cost, but then the Dubai court said, no, you didn't have authority, no cost to the party. So you can imagine that we're talking about millions of dollars there. So there are factors to take into consideration in this region when we're talking about cost. But generally speaking, entities that are used to arbitration, the mechanisms of arbitration and the costings of arbitration, they seem to be more comfortable with the process, but there is pushback from our perspective anyway as a local law firm for many of our clients to use arbitration due to the cost implications.
All right. Yes, you're right. Robert?
Yeah, it is a problem.
Yes.
The costs are perceived to be high. Partly that's due to the length of time arbitration takes, as well as the fact that they have to pay in most cases, the costs in advance.
Yes.
Yeah.
Which can be a huge sum if it's 3-member panel, because they're taking the fees for the tribunal as well as the centre's costs in advance. The claimants will, of course, be asked to pay 50% and the respondent 50%. The respondent, not unusually, will refuse, and so the claimant ends up paying 100% to allow the matter to go forward. This did used to create the idea that if the respondent hasn't paid, that could let you jump out of arbitration and into litigation onshore. I think they've actually closed that door now in a recent decision, actually the one that was dealing with jurisdiction and admissibility. Thank God, because of course that doesn't actually destroy the arbitration agreement. It just means that the claimant didn't really want to pay the entire advance up front. But it is a problem. And how do we deal with this? Would it be better for the arbitration centres to take money in stages rather than completely in advance? That opens a risk to the centre and the tribunal. Having said that, the tribunal more often than not doesn't get paid till the end of the matter. So the money's sitting in the centre's bank account, not the tribunal's bank account, which for us arbitrators is frustrating. It's, because cash flow is the lifeblood of any industry, including the arbitration industry. But these are problems that should be addressed and hopefully will be addressed. Some institutions like the LCIA do deal with their costs on an hourly basis, whereas so that the arbitrators will be given a set hourly fee, agree on that set hourly fee, and they will make claims in the way that you would as the representative. The court may or may not accept them, but certainly that's the way of dealing with it. Others like DIAC, it's a set sum, it's a fixed fee. And you can, if you end up doing far more work than was ever envisaged, try and ask for an uplift. If you get it or not is another issue. These are issues for arbitrators. Do you want to be an arbitrator, be aware of the cost implications and the cash flow implications. You need to be ready to deal with, certainly at the beginning, if you want to be an arbitrator without doing anything else, you need to be financially stable.
Stable, yeah.
But the parties, coming back to the original question, is a real expense. And if they're not a big company, that could be a very significant sum to find out cash flow.
Okay. Christopher.
Yeah, actually, just two comments. I mean, I think what Areen says, I mean, it strikes a chord. And I think going back to what I said, one of the reasons it makes arbitration popular is is you get, if I can put it like this, English-style litigation. Now, for people who've been brought up in the English legal system, and you see the costs awarded after a trial in the High Court, figures between that and the arbitration are not hugely different. I mean, there probably is an uplift, and I'll come to that in a moment. But you're effectively, by arbitrating, you're going for effectively a common law system. You're going for, if I may say so, a Rolls-Royce system, you know, witnesses, cross-examination, expert witness, and there's a cost to it. The other point that I would make, which I think is my own limited experience so far sitting as an arbitrator and indeed as an expert witness, I've noticed this, is that judges, and when I'm talking about judges here, I'm talking about commercial court judges in London, are generally more robust than arbitrators. Because what I mean is when people make applications that they want to amend, they want to bring in a new witness, this, that, and the other. And arbitrators, I think, for various reasons, understandably, because, you know, you've been appointed by the party and they're providing a service to the party. My own experience is that they are less, I mean, I've been involved in situations where I'm absolutely certain English judges have said no. But the arbitrator said, yes, you can do this. Now, of course, if you allow an application, you allow an amendment, you know, that is going to add to cost and may well add to time. And I mean, I'd be interested, maybe this is a topic that we can discuss outside this room, but I think arbitrators, they don't have this complete independence that judges do. Say, you know, this is PRO, this is PO1, this is what it said. Yeah. I'm not having any more of that. And that, of course, has a cost implication.
Yeah, I agree. It's true. Do any comments? Or you're fine. But any call on the cost. All right. I think, yeah.
Apart from the costs that arise from the arbitral fees, of course, there are costs paid to the legal representation. Yeah. But here the question is who to pay, and sometimes what the parties encounter is the problem of finding the right local firm, especially given the political situation now. The Russian parties are really trying hard to find the local firms that are willing to represent them. And this is mostly the case for Europe, and it is interesting to find out what happens here in the MENA region. So, Antonina, maybe you could share your experience. How does your company deal? Of course, you're working not in the Russian company, but then the sanctions affect many, and if you need to deal with the sanctioned country, how to
yeah, actually, yeah, I'm working in the US company, and the sanctions against Russia is very crucial for us as a legal counsels and how to deal with. Recently, the past 2 years, we closed all the branches and companies located in Russia. And here the issue, if you want to deal with the business in Russia, how to deal after all of that. So it's quite concerning. And there is me as a lawyer, there is a quite difficult question and concern. Do I need strictly follow the sanctions, or I have to be a lawyer and I have to follow the contract, what the contract says? So this question is still open for me and for my department. But mostly what we have a different kind of circulars from US and Europe, because our company also has offices and branches and production sites all over the world. So we have circulars from US and Europe, which from the one side, they are quite unified regarding sanctions, but from other side, they could be different. And still you have to follow both parts of the world. Okay, since the February 2022, different states has imposed coordinated by quite inconsistent sanctions against Russia. Okay, some may be very strict, some maybe not. Like for example, for European citizens, they are not allowed to even to communicate with our colleagues in Russia. Okay, even if those colleagues already moved and relocate from Russia, but for example, our company quite loyal to our employees, so they relocate people who want to relocate from Russia to another territories, keeping the position, keeping the jobs. But UAE employees, they're not allowed to communicate even with such employees. They have to have compliance permission every time if they want to send even a mail to this kind of people. It's quite complicated and quite difficult to comply with. We received a lot of mails from our employees saying, are we okay to communicate? Are we okay to deal, to make a business? Are we okay to reply to the emails from the people from Russia? It's quite frustrating because even though you're a legal counsel, you have to get a permission from the compliance office in US. Okay, so it's just like a lot of layers of different orders and different permissions to be getting from different departments in our company. This is quite frustrating. So this is my experience. I've been with company for almost 3 years, but the last 2 years were quite difficult from the compliance perspective. So what we usually do, we definitely send each and every transaction with Russia, if there is any. We send emails to our compliance, we get approval or not approval, and we move forward. So definitely this is not good for the business, but we have to deal with this. Yeah, this is my reply to your question.
And in cases where the arbitration and representation is needed, what do you think, can local firms help with this? And what are the advantages, or are there any difficulties when we issue sanctions?
From a local law perspective, which I will only speak to, so not from a perspective of an individual that's regulated by, for example, the SRA in the UK. I'm speaking from a local law perspective. We do not like sanctions from anywhere, not just Russian sanctions, but anywhere, because the UAE, particularly Dubai, is a place of commerce and business, so sanctions are seen negatively, very negative. However, they are a reality, and a serious reality, and they do affect what we can do and what we can't do. However, from a local law perspective, we have far more freedom in relation to who we can represent and what we can do, which I think is great, obviously. And local law firms generally now in this jurisdiction freely represent Russian entities. Of course, sanctioned Russian entities are more difficult. Of course, people will be aware and much more specialized than me in relation to OFAC licensing and et cetera, However, we do represent Russian entities in this law firm in this jurisdiction and also in other jurisdictions, in arbitral tribunals, before arbitral tribunals, sorry, and in other areas, advisory work, and also in some court proceedings, because we believe that the right to litigation, to be represented, is a universal right. And as far as possible, that we should be apolitical when it comes to disputes in relation to the Russian dispute, but also across the board. Historically, of course, this nation has benefited from its links to Iran, for example. Sanctions has been an issue for this jurisdiction before the conflict in Europe currently. So sanctions is a reality. I think from our perspective of a local law firm, we are happy to represent clients from wherever they come in relation to their disputes. We view their issues as we view other issues, with the caveat that, of course, we want to get paid, because we're in this industry to get paid. And that is an issue as well in relation to representing certain entities because of payment problems. We have unfortunately had to reject some instructions that we would have liked to take simply because of sanctions, and we didn't have the correct approval that we need to represent certain entities. So it is an issue, but we are grateful and thankful that we as local law firms have far more maneuverability to represent clientele that many other international law firms will be unable to. The final point on that is that I have colleagues all around the world, in London and other jurisdictions, that would like to represent certain entities, and they believe that in terms of natural justice, these entities have a claim and have been, in certain circumstances, prejudiced and not dealt a very good hand. But they are not able to do so because of their regulatory boards and compliance departments, etc. We here have more flexibility in that regard, for sure.
It's true, it's true. This is what we face. Robert, do you want to comment on this? Do you have an experience?
I think in my experience, the local firm position, absolutely correct. There are still potential issues, payment being the biggest one. But you do need to make sure you're not breaching the sanctions. Now, from my perspective, as an independent counsel, as a UK barrister, if I'm acting for a party, I need to ensure that I am not in breach of the sanctions or my commitments to sanctions, the UK's commitments to sanctions, I should say. And the Bar Council are actually supportive of giving representation to everybody. So that would include Russian companies and Russian individuals. Of course, bearing in mind UK government's sanction policy. So if I to be approached by a Russian entity to represent them, I would be initially thinking, yes, of course they deserve representation. My feelings on the matter are neither here nor there. They employ me to do the best I can, that's what I would do. But I would need to first check with the Bar Standards Board that I'm not in some way in breach of the sanctions and to make sure that I am given clearance, if I can put it that way, to so act. Payment, of course, is always going to be an issue. You want to be paid, and in such circumstance, it's not unreasonable to say, actually, you need to pay me in advance. It's the nature of the beast to a large degree. As an arbitrator, obviously you rely on the arbitral centre to obtain the fees and then pay them out to you. If I was acting ad hoc and therefore not under institution rules, again, I'd have the same issue. I'd need to make sure that payment is being made and can be made and is not in breach of some sort of sanction. So there is more flexibility here. As a UK barrister, I'm aware that I have obligations that I need to comply with, that I need to check first. I wouldn't be able to just say to a potential Russian client, yes, of course I can. My answer would be, yes, I'd love to. I need to check one or two elements, and hopefully it will only take a short time. But assuming I get clearance, I'm happy to act for you.
That's an issue I've had to deal with. So I happen to be a US national and a German national. So, and then my chambers is in the UK, so affected by all three regimes. But I found that although it raises practical problems, I tend to think it's at times overstated in the sense that, we're lawyers. We must represent there's a fundamental right to representation, and it's a legal problem, figure it out, right? You can work your way through these things, find answers to it. And actually, it seems like the bigger obstacle at times is when you're dealing with international firms, it's just simply a policy decision with the firm. We don't want to deal with it, right? And so we won't take on the client, although there may in principle be a solution. And the payment issue, which I think is a similar bureaucratic issue, is the banks doing the same thing. But I'm acting in a case in US litigation with a sanctioned entity. Pretty much all three regimes have general license for providing the service. And it's slightly different the way they deal with payment, but there's a recognition, I think, on the policy level, the governments that people need to have their fundamental right to representation. And don't forget the people that they're litigating with need to have their dispute resolved. So, yeah.
I understand your concerns, yes. Any comment from your
No, I think
perspective?
what Emily said is actually right. When the first sanctions cases came following 9/11, thanks to the UN sanctions, people responsible. I mean, there was already a carve out on grounds of fundamental rights for legal representation. So clearly, what Drew says is absolutely right, and I think it's, if you like, the devil in detail.
Yeah, it's true. Areen, we are jumping to the next topic. Attitude of the states and the courts towards arbitration. Is it what the trends in recent case law? And
Yeah.
what do you think about
So
it?
as I alluded to at the beginning, there has been a seismic shift,
Mhm.
if you will, from 10 years ago, where the courts, the national courts, the sovereign courts of the land here, were very anti-arbitration, to a status quo now where they are extremely pro-arbitration, and that's provable by the judgments that are being issued across the board in the UAE, but particularly in the two main cities of Abu Dhabi and Dubai. There are exceptions to every rule, of course, and there are some problematic judgments that we do come across. Two of them that we've alluded to in this conversation, and that I think are noteworthy, particularly in relation to, again, public policy. Public policy is an issue that is difficult to define in many jurisdictions. I mean, you can read books about this issue, but in the Gulf region, and particularly in the UAE, it is a sensitive subject. And it is one I believe public about because it's dynamic, it's changing, right? So in the early days of the UAE, public policy was related to things of public norms, i.e. Islamic law related issues, interest, alcohol, etc., etc. Now, of course, that's a distant memory. The UAE is not a very Islamic nation. No offense to anybody in the audience, but it is a nation that wants to be at the forefront of commerce, of modernity, of etc., etc. It does not want to be an Islamic state of sorts. Therefore, you see in our legal system that interest is absolutely fine, for example, in polar opposition to Saudi next door, etc., etc. And of course, everybody knows that we can very soon play a hand of poker in Ras Al Khaimah next door as well. It's very new to the UAE's jurisdiction. So what I'm trying to say is public policy is shifting and it continues to shift. But there are still issues in relation to arbitration when we're thinking about public policy that have not changed, i.e. in Dubai, and practitioners that have been based here will know this, a staple of the economy is real estate and construction. So the first case that caused controversy in this jurisdiction, and even we saw articles popping up in London about this issue because of the importance of arbitration, was on the registry, the ownership registry of the Dubai Land Department, and the fact that you could not arbitrate in relation to an issue that touched upon that matter. You can arbitrate about the unit or about if it's been completed, etc. But the actual issue of registration in the ownership register was unarbitrable. You could not approach it, and that's of course remains the case to this day. So the government here do guard jealously certain issues, of course, that they do in other jurisdictions. The very interesting case and what I'll conclude on is in relation to separability of an arbitration clause, which I think there is a conflict currently in our arbitration law. The issue is clear of separability. It is in the vast majority of other jurisdictions. The fact that the underlying agreement can be terminated does not affect the validity of an arbitration clause. However, last year we found a judgment in the Dubai courts which created noise that said the opposite to that. And it went all the way to cassation, the final, the highest court of the land, saying yes, because it touched public policy, the issue is that the underlying contract is invalid, therefore the arbitration clause is invalid. Therefore, the entirety of the proceedings are also invalid and void, which goes against not only the arbitration law, but hundreds of other judgments before this judgment. Of course, when we went to court and asked the judge that issued, the panel of judges that issued this issue, they said, we're not bound by precedent. Why are you giving us grief? We can actually look at the next thing, we can go the other way. So,
The answer is quite.
yes.
Yeah.
Legal certainty.
Absolutely. Disaster to legal certainty. There is no legal certainty in the issue. We can advise on trends, we can advise on principles, That's the issue, because judges have that authority and freedom to do as they wish it, if you will.
And of course, the question would be in that particular case is, if it hadn't involved public policy, would they have in fact decided that way? For public policy, from my understanding, because of course the judgments aren't reasoned in a way that a common law judgment would be reasoned, so sometimes it's a little difficult to discern exactly why a court decided in a particular way.
Yes.
But public policy, I think, in this case was very important.
I think you're right. And just very, very briefly, I'm sorry, Christopher, I know you want to say something. But on this case, and it was the definition of public policy that we were talking of, this case related to the company's law. It was about the nature of an entity in a partnership. It wasn't to do with the sensitive area of military or whatever. It was to do with a Emirati partner, because previously to a few years ago, you had to conform to 51% of the shareholding of being an Emirati national, and then the rest, the remainder being of any other nationality. And of course, the law changed, and this case was brought by the Emirati saying, I didn't get any profits, we agreed to this, etc., etc. And the public policy argument was that an addendum to the 51-49 split was against public policy. So that's what I'm saying. This was an anomaly to us, this judgment, but that happens in this jurisdiction. It's not that infrequent.
Yeah, it's not. Okay.
Well, what I was going to say, which in a sense, it's a proof of pudding, is that in eating, an English judge many years ago said public policy is an unruly horse, and that's a judge in England. Obviously, transpose that to Dubai, and I know from my former court what is public policy. It is subject to change.
Yes.
Yeah, it is. Okay. We're moving forward to the next question. Quite interesting, sophisticated, complicated, and unclear. Enforcement of domestic or international arbitral awards. Drew, you want to comment something? Huh?
Yeah, and one thing I could just use in the example
We just start to discuss,
is Saudi is important. I mean, so on the one hand, you do have a robust enforcement regime, but when you're looking at the seat, obviously public policy, the unruly horse, it's going to be different. And that's true. I mean, anywhere. There was just a couple of years ago, or last year, I think it was, there was a award that was refused enforcement in England on grounds of public policy that came from California because they didn't apply consumer protection law. So it's not that unusual. What it does highlight, however, is that when you, and I think this is going to when you have your arbitration, when you're choosing your seat and when you're choosing your counsel, or at least your legal advisors, you need someone, it's different pressure points than litigation. You need someone who understands the seat, the enforcement issues, and then also, the potential challenges to the award. So again, in Saudi, very modern arbitration system, very good institution, generally enforcement, but Saudi law says it's actually in the code, they put in Sharia principles. And if you go against the Sharia principles, that's against policy. That part of the award is not going to be enforced, might not be enforced at all. And had some interesting statistics from the last 3 years of Saudi awards. 95% of them have been enforced. Last 5%, almost entirely awards where they had interest. So now you won't have that maybe in Bahrain or UAE, but when you're choosing your seat and also you're choosing a place of enforcement, that's where you really need the level of expertise to make sure you aren't stepping across that line.
Wasn't it right that of the cases not enforced, interest, that was the only aspect of Sharia? No other aspect of Sharia has been used to avoid enforcement?
Yeah, I think as far as Sharia is concerned, there were a couple other grounds, different grounds, but they weren't Sharia grounds. Yeah, that's definitely the most common. And I think, as you mentioned before, I mean, that just means if you don't take your international arbitration with non-Saudi parties to arbitrate in Saudi Arabia if you want to collect interest, right?
Mm-hmm.
But obviously, if you're dealing with Saudi parties, that's probably already baked into the dispute that you're not going to be getting into. So it might be a bit of an understanding problem in that sense.
So the fear about Sharia is probably not as great as perhaps we in the West might believe.
Perhaps, I mean, if you look at the last 3 years' practice, but I mean, one of the other big issues in Saudi Arabia is that they don't. Now, I won't say this about the arbitration rules because arbitration rules recognize choice of law, the Saudi arbitration rule, but you don't have choice of law recognized generally in Saudi domestic law, right?
Mm-hmm.
So I think that one issue you can have is if you don't think you can choose a governing law non-Saudi for your contract, I think that's going to get you around the problem of Sharia principles, right? When it comes to enforcement.
Sure.
Your English law or Russian law or whatever contract is not going to trump at the enforcement stage the Saudi Sharia principles.
Thank you for your view. Areen, do you want to comment on?
Sure. Enforcement is something that we specialize in, of course, in the local law firm. Simply primarily because the majority of assets held by the majority of litigants are onshore.
Yeah.
The DIFC is fantastic, but it's a small geographical location. Assets of a nature that you can attach, freeze, sell, etc. The majority of them are onshore. So there must be, and I think Drew, you're alluding to that there must be local knowledge to be efficient and effective in enforcement in any jurisdiction. And it's the same here. It's true here. There's a specific mechanism, for example, for mortgage enforcement. If you don't know it, you won't do it very well. So, and it's not just what's written on papers, as many practitioners will tell you. It's you have the experience is key. The personnel at the land department, for example, and how to approach them, what applications to submit. These things are also extremely important, not simply the black letter of the law on these issues. What's very important and something that we deal with constantly as well is the enforcement protocol between common law courts in the UAE, both ADGM and particularly the DIFC, and how to bring the enforcement proceedings onshore to actually enforce against an asset. And that's something that has challenges, of course, challenges predominantly in relation to timing.
Yeah.
You want things very quickly for obvious reasons. Dissipation of assets is an issue, particularly in this jurisdiction where people and entities can be coming and going more frequently than other jurisdictions. But no, it's something that has improved vastly in recent years in terms of efficiency, in terms of speed. But we do have issues. One of the major issues is that, particularly in relation to free zones, there is very little transparency in terms of if you have a judgment and you want to enforce it, you can enforce it eventually with time, but getting the information of the presence of assets in a free zone is difficult. People come here in certain free zones because of the privacy that they are given. So we have many challenges in enforcement, but it's something that's improved vastly in recent years. Challenges to enforcement are now almost non-existent in terms of the challenges that used to throw a spanner in the works routinely. By way of example, and many practitioners of arbitration will tell you, you couldn't enforce previously if not every single page was signed. Arbitral law, things like that. And you hear stories and we live with pathetic issues. Those are now no longer
right.
Which we're very, very happy with. So it's difficult to stop an enforcement nowadays in Dubai. When you have an award, generally speaking, if there's an asset, you enforce against it, which is fantastic. But I would like to see personally, you mentioned the enforcement of foreign awards, for example. I don't understand, and perhaps people can, when we open up to the audience, can tell me why on earth. I mean, there was a recent amendment to the arbitration law. Why on earth we didn't include a specific provision for the enforcement of foreign arbitral awards in that law? Because what we have to do is we have to now refer to the civil procedures law, which has changed in the last 6-7 years about 10 times. I don't see they had an opportunity to fix something, and they left it unfixed, and that's one issue. And we're talking about enforcement that occurs quite often.
Yeah, it's still open. Open question. Yeah. All right, thank you very much. Thank you for your, okay. Anybody else want to comment on the enforcement?
Just, I mean, taking up Drew's point, I mean, yeah, it is actually critical to find out how it's going to be enforced. I mean, there was quite a famous arbitration that took place in the Netherlands, commercial arbitration, where one side raised a competition law issue, and then it went to the Dutch court, and the Dutch court, there was an issue whether that was enforceable.
Mhm.
It then went to the European court, and they said, well, yeah, of course, we've got Article 5 of the New York Convention of Policy, but, and this goes back to your consumer protection case, competition law in the European Union is effectively in the DNA. And so the compromise was reached. Yes, you can arbitrate this, but it's got to be done properly, and you've got to have the ability. The sort of safety valve is that when you come to the enforcing court, it must be able to make a reference to the court of Luxembourg to see that the law has been properly applied, and that's the sort of thing that Drew was talking about.
Merits review.
Sorry?
It's like a merits review.
Yeah, it is exactly. It is. And I have a case in Sweden where we're challenging an award on exactly that basis. You're entirely right.
Interesting. Thank you very much. We discussed a lot on onshore. What about the offshore? Offshore arbitration, DFC or ADGM? Anybody wants, or I think Drew wants to mention about Qatar. Yeah.
I mean, I will defer somewhat to the locals with more experience, but I think looking at it from the, outside looking in, one of the perhaps unknown jewels or advantages of arbitration here, I mean, there might be perceptions of its, being a bit sort of foreign or the jurisdiction, which actually, by opting in your seat to DIFC or ADGM or in Qatar, the QFC, you can actually have your supervisory court be a panel of internationally renowned judges and get very good quality and expedited review of supervisory applications and challenges. And that ought to give folks who are perhaps less familiar with the local courts or the local norms or policy, a level of comfort that they can get an efficient management of their arbitration without some of the more unusual things that you might get in the onshore courts. But I defer to my colleagues here on some of the details of that.
It's probably worth mentioning that in the DIFC, in the aspect of diversity, there are good Emirati judges in the DIFC. It's not just international judges. There's a nice mix. And I'm pleased to say that the Emirati judges having been brought up in the civil system are applying the common law system pretty well in the DIFC as well.
True. Yeah, we'll quickly talk about now interim relief in support of arbitration. If anybody wants to comment on this, it's quite sensitive topic as well. Areen?
Yeah, I mean,
sure.
Interim relief is something that is important not just in arbitration but in litigation, particularly in this jurisdiction, as we mentioned previously, the kind of transient nature of certain individuals and even entities sometimes. The issue is that people do tend to run away when things get tough.
Yeah.
So interim measures in terms of precautionary attachments, we call them, or freezing orders, I think in other jurisdictions, are commonly used and utilized in the local courts in support of arbitral proceedings. We are quite limited in the onshore courts in relation to the interim measures that we have at our disposal. The DIFC courts and the common law courts have more. And they have, I think, apologies, I can't remember which co-panelist was mentioning anti-suit injunctions and these issues. We don't have those tools at our, we can't use them at all because they are against the litigation system here. They are deemed as anti-justice for some reason. So what we tend to advise on, apply for and utilize as counsel in these situations is precautionary attachments, which is, I think, the most often used interim measure. and is something that we see quite often in terms of our arbitral proceedings. And we don't have, of course, as you know very well, the system of disclosure that the common law jurisdictions have. So we don't have, for example, orders that you have to produce this and you have to produce that in the onshore courts. So honestly speaking, it's only the integrity of an asset that we usually see interim measures used for, from our experience as a local law firm. Because to be quite frank, that's what our system provides for. The other interim measure that's often used is a travel ban. To stop people running away. Yes, which is controversial to some, but often used here. Often used and continues to be often used, particularly in litigation, but also increasingly in arbitration, which causes fear for not just parties, but also arbitrators.
Yes.
It puts people off running from jurisdictions.
And you only find out when you get to the end.
You're trying to want to time it for the early summer.
Yeah, absolutely. So from a local perspective and from our firm's perspective, those are the tools that we have at our disposal and we see often applied for and used. But we are very limited in relation to interim measures in this jurisdiction.
Thank you very much.
In arbitration, one of the aspects that I find interesting is the use of peremptory orders. In common law jurisdictions, the unless order, unless you comply by certain date with certain order, you're not allowed to either put in that evidence or indeed perhaps you are no longer able to argue your case. It would just go forward on the information we have. But you do need to look at the institutional rules, rules, to see if you do have that power as a tribunal. Not all tribunals will have that power, and it's arguable, but it's probably a stretch too far to say that the general powers of the tribunal allow for a peremptory order. I think they're a good idea personally. I think it keeps the parties in line. But that's a potential issue, especially here where you have the civil law and the common law codes and different rules being used generally.
Okay, thank you very much. We are running out of time. I still have more questions, but we don't have time. So takeaways, very quick, 1-2 sentence, please, from each speaker. If you don't mind, Katarina, would you like to start?
I think what we've heard from many of our experienced panelists is the thing that something was wrong, but then it was changed. And this is a great thing because you see the tendency, the constant drive for improvement. And I think this shall continue and hope this will continue. And in the near future, Dubai, there are all reasons to believe that the UAE and MENA countries will be one of the most popular global choices for arbitration.
Great.
I think I would say, to me, the theme is you've got a wealth of choice and a good, strong framework to have international disputes resolved here. The flip side of that is, as lawyers and you're advising parties on the contract, you need to take full advantage of that and to make sure you avoid the pitfalls that are needed. The tools are there, the toolbox is there if you want to use it, but make sure you figure those things out in advance.
Thank you.
I agree. On a slightly different track, I think from the international aspect and viewpoint, arbitration, not only here in the UAE, but in Saudi as well, and Qatar and the MENA region, is actually more friendly than it's been understood in the past or accepted in the past. And I think that international companies can be more confident in arbitrating in this area, certainly in the UAE, and should not perhaps have the level of fear that they used to have.
Yeah, it's true as well.
Yeah, I would agree with that, really. I think it's a great place to do arbitration. I think it's a great place to do business. I only see that situation improving and institutions and the legislator here strengthening the tools that we have at our disposal as practitioners and also as institutions. So I can only see improvement. And that's one of the great things about this jurisdiction is the dynamism and the speed of change. Of course, it has its negatives, but generally speaking, from our perspective, it's a positive. We think a positive.
Yes, well, I'm going to make a little plug for Areen and his firm. I think when you look at the development of law, common law developed in London, you had specialist barristers, solicitors, you've got a legal ecosystem. And that's what I can see has developed here in Dubai. And I think, to me, who's somebody who's not from this region, I mean, I can see one's got very sophisticated legal infrastructure here. You've got really good lawyers who can advise you. And I think, if you've seen, I mean, there are obviously pros and cons of arbitration, but I think the reality is that if you need assistance how to put a clause in a contract with arbitration, this is a good place to go.
Thank you very much. I think we probably have a little bit time for Q&A. Anybody? Of course, Sean. Yes, please.
James, I have two quick questions, and they really go to the subtopic of real obstacles to dispute resolution that are specific to the MENA region. And they touch upon issues that we've already raised. The first one is this, that is the attempt to blend civil law and procedural, civil and common law procedural elements, just a gloss that fails to address the underlying issues that we see in practice. So what I'm thinking of is the rules of arbitral institutions tend to say that they're a mixture. They adopt parts from civil, part from common law. The IBA rules of evidence do the same. They say this is a deliberate attempt to blend. You look at the Prague rules, they say, no, we're civil rules, equivalent to civil jurisdiction based, and it's not a common law system. But the real problems are, it seems, the way that the two different legal traditions deal with sources of law. So should we be referring to Sanhuri and professors? Because in England we don't. Should we have document disclosure? It's fundamental to common law systems. It's anathema to civil law jurisdictions. Should we have live testimony and cross-examination of parties? Parties in civil law jurisdictions are not usually allowed because it's assumed they're going to lie to look after their own case. So there are these fundamental differences lead often to positions where you get civil law lawyers on one side and common law lawyers on another side within an arbitration, and both are absolutely convinced that the other side doesn't know what they're doing. That's what they think. They're hopeless. They're doing it wrong. So that's the first question. Are the fundamental issues still there? And does a gloss of blending rules make any difference? Second question is arbitration's flexibility, which is often put forward as a benefit, actually a weakness in the region? And it goes to one of Christopher's points that you said you had an ICC arbitration, and the way it was being conducted was pretty much like an English law litigation case, because everybody was doing what they do in litigation and doing what they've been trained effectively. Now, there's an argument for saying that international arbitration looks like litigation in most jurisdictions. So if you have an arbitration in Sweden, it looks like a Swedish court case. If you have arbitration in France, it looks like a French court case. One of the reasons for that may be because that's the way the lawyers are trained. They're used to doing certain things. They're used to being able to rely on certain sources of law and bring certain evidence to produce it. Now, here we have a peculiar environment where we've got a big mix. We have lots of international practitioners coming from different jurisdictions, and they're thrown into the same procedural context. That doesn't happen in the DIFC courts because everybody has to be common law familiar. You're all sticking with the same rules. But in arbitration, doesn't it lead to commercial or a lack of commercial certainty when you don't know who your arbitrator is going to be, and you don't know what type of case, civil law based or common law based, your opponent is going to bring? And I think that's something specific to this region because of the mix. So those are the two questions. Are the attempts to blend rules just a gloss? And secondly, is arbitration's flexibility actually its weakness here?
Well, perhaps I could just, I mean, I was on the European Court for 8 years, and so I was a common lawyer, the Irish judge. All the rest were civil lawyers. And I think this distinction is, in my view, grossly overblown. Because if you take, for instance, professors, yes, you cite professors on the continent. The first case I did in the Court of Appeal, the master of the rolls, John Dalston, cited a book And this is a little in-joke for people who didn't know how the English legal system works. I'm citing this book, which is the leading authority in this area, even though happily the author is still alive, because there was a rule in England that you would never cite from a book unless the author was dead. I could never understand the logic of that. The logic of that was that he could never change his mind. And I'm writing an article about a recent Supreme Court case where they not only cited professor articles, they've actually cited blogs. So it's really completely, in my view, yes, one comes from a different tradition, but when you sit and you analyse the issues, actually, and I've sat, say, with a lot of people in continental jurisdictions, the difference is not that great. And coming to your second point, I'm not sure I would necessarily accept the premise that if you're sitting in Sweden, it's going to be done, if you like, in a Swedish style way, because it depends who the arbitrators are, it depends who counsel is. And I mean, I come back to the point, and this is, I mean, arbitration in a sense, it's choice driven, and it's got sophisticated customers who wish to have it. Is by and large, people are buying into, or they're advised by law firms that if you want the dispute resolved in this sort of way, it needs certain facts, and you've got a problem about the local arbitration is what you buy into. And yes, of course, if you have, I was an expert witness in a case in London where none of the arbitrators were English, and we had a professor for one of the arbitrators, a professor from Latin America, but it was, if you know, I was there. It was actually the first time in my life I was cross-examined. It was basically like the English commercial court, even though none of the arbitrators were English, because that is the way that the people who brought this case, they bought into that system, and that's how they want it resolved. And I think, and I would stop because I've gone on too long. I mean, I think the important point here is the diversity point, which I'm a great believer in, and that I think there's absolutely nothing wrong. It's actually, if you have a continental lawyer on the panel, I think you would be surprised if there's, I mean, in your own experience may be different. Be surprised if they say, well, there's two totally radical ways of dealing with this case.
Thinking, building on that, I'd go back to the points I made a little earlier. Depends on the tribunal as well. If you know you've got civil lawyers and common law lawyers representing the parties, you need to be very firm and clear about how the process is going to proceed, what that actually means, what's expected of counsel. And if they don't understand, please ask a question to ensure that everybody's on this level playing field. So that's where you need a strong tribunal. And it may well be that we have issues where you don't have a strong tribunal. That's very much a party choice.
So I just kind of a little anecdote. You said, well, on the continent, parties don't give evidence. Everybody thinks they lie. Well, I mean, I know from my own experience, there are many continental judges who will not listen to a word the lawyer says on the basis that a lawyer is a hired gun, and that they will go to decide, particularly if you're a former university professor, I've got the sort of law somewhere in my breast. I'm not interested in what the lawyer said. It leads to all sorts of difficulties. One of the reasons you can then get a decision which is based on something that hasn't been argued in front, because somebody thinks, well, actually, these lawyers are a bunch of fools. I'm not even going to engage with them and say, what about this point? But the real point of the case, which only I know, because then I'm very clever, is this. Now, I don't myself think that's a good way of proceeding. I mean, it's certainly not procedurally fair. It may be that the lawyers are a lot of hicks, and that actually the key point is, but then you need to put the point to the lawyers. And that's, again, I think another strength of the English system, is that there is this great rapport, not just in court, but also in arbitration, between the arbitrators and counsel. One doesn't think that they're there to mislead. And I say, many continental judges, and they think that is the role of the lawyer.
I would love to say something, but I think I'd risk just repeating what very good comments by Christopher. To sum it up, I'd say I think I agree that it comes down not to the rules, which are designed to be flexible. It comes down to the people populating the arbitration. It comes down to the counsel and the arbitrators, and the choice of tribunal or arbitrator is absolutely critical. Whether it goes on, it accommodates those, or if it goes off the rails. So make a good choice of your arbitrator, or at least get a sensible procedure to get something predictable, where you have to properly manage the process, I think is the answer. because the rules out there are can accommodate common law arbitration, they can accommodate civil arbitration. And we've all seen, I mean, no doubt yourself, I've sat in arbitrations where it's English lawyers on both sides. One side is experienced in international arbitration, the other runs it like it's a high court case, and it's completely tone deaf. I mean, you can have the same problem in the very same system. So, you know, it comes down to keep the section.
Can I apply local law and take it that Areen's silence is that he agrees with me?
I understand why you asked the question. I've sat on many tribunals, although I do agree that radically different approach isn't the norm. There are differences, nuances between the two systems. Emirati arbitrators or Arabic speaking and from the Arab jurisdiction have a specific way of thinking, a specific way of and expectations of how things are going, which way things will go. And there are some areas of conflict. But generally speaking, and obviously these things are assessed on a case-by-case basis, I don't believe that the different schools of thought are at loggerhead. There are differences of opinion, there are differences of approach, but generally speaking, a case is based on its merits, and the merits sometimes are obviously favouring one side as the other, with very few exceptions, from my experience, which is of course humble in comparison to some of my co-panelists. But some of the cases that I've been a part of the panel on, the only real disputes are in relation to evidence, for example, as you mentioned. Oh, I prefer to use the civil code-based way of dealing with evidence as opposed to the IPA rules, and things of that nature. But when evidence is before a tribunal, it's before the tribunal, and there it is. So I understand why you asked the question. I have sympathy for the concept that you raised, but I do actually agree more with Christopher that generally speaking, there isn't that much of a dispute when we're sat at the tribunal level.
Okay, I don't know if you still have time for another.
Actually, I do have a question, if I may. I have a question, Mr. Robert, about the compliance of the arbitrator regarding the sanctions. Does the arbitrator have to comply to the sanctions? And what is the impact? How can we differentiate the impact from complying between complying the sanctions and the public interest regarding the resolving conflicts?
The answer to that question is actually rather dependent on where the arbitrator is legally qualified. For example, I as a UK barrister, even sitting as an arbitrator, I have to make sure that I comply with the ethics and any rules of the bar, and that deals with, of course, the sanctions aspects as well. What my position actually is. I think if you're sitting as an arbitrator, but you're not a professional, not a legal professional, you can, of course, be an arbitrator without any qualification. Then the issue of sanctions is probably less of a problem. But you still need to look at the law of the country that you're operating in and how sanctions are being dealt with by that country. So in the UAE, it's a relatively light touch, but there are some aspects that you need to be aware of. I think it comes down to the individual to a much degree, where they're qualified, how they have to deal with sanction issues, or how they have to get permission is the wrong word, but how they can actually make sure that they are safely able to provide services, because that's what we're talking about, to the parties, can't in breach of those sanctions, or you have some sort of dispensation.
If I may ask, what will the tribunal do if the sanctions are applied after the formation of the tribunal? Because the tribunal is a legal entity; it is independent from the individuals of the tribunal. So, what should the tribunal do?
It's an ongoing basis. If sanctions come in the middle of an arbitration, the tribunal has to consider their position, and if ultimately it means that they can't continue, that's very unfortunate, but that's the position. Hopefully, in most cases, that isn't the position. But you can't just carry on because it's okay when you were appointed.
Thank you.
I think we are done for today. Please give applause for our panelists. Everyone be here. I hope you enjoyed the topic, our speakers, and see you next time.
Thank you, everyone. Thank you.
Okay.